On behalf of the Karnataka India section of the International Commission of Jurists and Karnataka Jurist Trust, thank you for coming to this evening's talk on Constitution of India, 75 years. May I request Justice Bopanna, Justice Dikshit, Mr. Acharya, Mr. Uday Halla, and Mr. D.L.N. Rao to kindly please come onto the stage. Thank you. May I request everybody to please kindly put your phones on silent. We start this evening's program with an invocation, Maitrem Bhajatam, sung by Bharat Ratna M.S. Subbalakshmi. Please stand for the invocation. Thank you.
अखिलहृजेत्री मैत्री भजत अखिलहृजेत्री मैत्री भजत अखिलहृजेत्री आत्मवदेव परान् विपश्यत आत्मवदेव परान् विपश्यत युद्धं त्यजत स्पर्धां त्यजत युद्धं त्यजत स्पर्धां त्यजत त्यजत परेष्वक्रममाक्रमणं त्यजत परेष्वक्रममाक्रमणं मैत्रीं भजत अखिलहृजेत्री भजत अखिलहृजेत्री जननी पृथ्वी कामदुःखास्ते जननी पृथ्वी कामदुःखास्ते जनको देवः सकल दयाळुः जनको देवः सकल दयाळुः दाम्यतद्रक्त दयध्वं जनता दाम्यतद्रक्त दयध्वं जनता श्रेयो भूयात् सकलजना श्रेयो भूयात् सकलजना श्रेयो भूयात् सकलजना
Thank you. May I request Shri Uday Halla, Senior Advocate and former Advocate General, to kindly deliver the welcome address. Sir.
Justice Bopanna, Justice Krishna Dikshit, all the learned judges, Senior Counsel, friends, nothing gives me greater pleasure than welcoming Justice Bopanna, one of the most popular of judges that Karnataka had. When he left the shores of Karnataka to adorn the Chief Justiceship of Guwahati, there was a big function in the banquet hall. The banquet hall was overflowing, which merely showed the popularity of the judge. when we all get up in the morning, the cup that universally cheers us is the kappa, the morning coffee. He hails from the land of coffee and honey. And that's the reason why he's so amiable and so approachable. I'm sure all the seniors, we have had the pleasure of appearing before him. The youngsters, as I see, may not have had the pleasure of appearing before him. In the morning, at 10:30, there will be 50 people standing to request him to have their matter at 2:30 or the next day morning. In the morning, at 10:30, you will see a benign smile on his face. After we harass the life out of him, at 4:45, you will see the same benign smile. The man of great erudition who never showed it. It's just, I can only say this. When he left the Karnataka High Court, there were tears in the eyes of many youngsters. Reason was simple. He was one of those judges who always felt that judiciary is there to ensure that every tear on the eyes of a litigant must be wiped out. And he ensured, sitting in his court hall, that was what would be done in his court hall. In fact, when he went to Supreme Court and when he retired, many seniors told me, "Sir, we are losing one of the best judges that the Supreme Court had." Reason is very simple. One is relief-oriented nature. Second is amiable nature. I don't think anybody has seen him lose his cool in the court hall. How much soever harassment may be there from us lawyers. I remember once a youngster, he had absolutely no case, a case for dismissal. When the argument went on, Justice Bopanna heard him and then said, "Okay, I'll issue notice," because it was not a case for interim order. The uppity youngster, he said, no, you have not heard me. You'll have to hear me. So he was raising his voice. Justice Bopanna said, "All right, I'm sorry. I will hear you. Please go ahead." That youngster argued for half an hour. Justice Bopanna, without losing his cool, he passed an order dismissing because that was what it deserved. He went out of his way to help the youngster, and the youngster thought that, his brashness is what will count in court. Well, friends, I can only say this. There has not been, we have had a galaxy of judges, and I would rate him as one of the really best judges that we have. In that galaxy, it's our pleasure today that he is with us to deliver the very important lecture on Constitution. We are all eagerly waiting for him. I'm sure the youngsters will be benefited by his erudition. One thing I can tell you, he is one of those judges who is today in great demand for arbitration. Why? Reason is simple. Honesty and integrity and competence, both of which we find in him, and one of the most amiable of judges, and a gentleman to the court. We have all said Kurgis are the martial race. But here is a gentleman who is so gentle, but at the same time, he has a hard heart. He can be very firm in his decision, as is needed for a judge. But it was his ambition, and he fulfilled it to the core, to give succor to every litigant who came before him. It gives me great pleasure to welcome him. Thank you very much, sir.
Thank you very much, sir. May I request just Mr. D.L.N. Rao and Vaishali Hegde to kindly give a token of our appreciation to Justice Bopanna, please. Thank you, sir. May I request Mr. R.V.S. Naik to please kindly to present a token of our appreciation to Justice Dikshit.
Nobody to carry this for me.
You know, there's always a faux pas. I did that just now, without even welcoming Justice Krishna Dikshit, who is the chief guest here, presiding over this function. I owe an apology, a profound apology to him. Sir, Sir, we all, when we go abroad, we will hanker for chili, sir. We have all seen that. Whenever we have gone abroad, whether you are a vegetarian or non-vegetarian, you want some chili. And chili has its own flavor. Without chili, we can't exist. The Indians, we can't exist. So you are as important as the coffee or the honey. Second faux pas. I did not even welcome the learned judges who have come here to be a part of this function. Each one of them has been, you know, we have today from court hall, you know, the youngsters, they work so hard. It's unbelievable. The younger generation of the judges, we have the leader here, Justice Krishna Dikshit, sitting here, and all the other judges here who work so hard. It's really heartening. And I also must welcome each one of you individual lawyers, senior counsel, as well as the guests who have come here. Please pardon me for my mistake that has occurred. I'm sure you will pardon me for that. Thank you very much.
Thank you very much, sir. May I now request Justice Bopanna to kindly deliver the day's address. Thank you.
Honorable Justice Krishna Dikshit, Judge High Court of Karnataka, Shri B.V. Acharya, Senior Advocate and former Advocate General, Shri Udayavalla, Senior Advocate and former Advocate General, Shri D.L.N. Rao, Learned Senior Advocate, Honorable Judges of the High Court, former Judge Justice Venugopal Gowda, who is here, Learned Senior Advocates, all other advocate friends who are here, invitees, ladies and gentlemen, staff of the High Court. A very good evening to all of you and wish you all a very happy New Year after the 1st of January and Sankranti both. And I also wish you all well on this, the golden diamond jubilee year of the Constitution as well. We, the people, including you and me, have given ourselves the Constitution by declaring in the preamble itself to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity to promote among them all, fraternity, assuring the dignity of the individual and unity and integrity of the nation. Because though we say we all of us have given to it, but I think most of us were not there on that day. Maybe like Mr. Acharya and others who have given the Constitution to us, and we are here to keep it. In the words of Shri Palkiwala, the preamble is like identity card of the Constitution. Our Constitution has an extraordinarily forceful and meaningful preamble which reflects the pledge contained in the Objectives Resolution of 1946 to guarantee basic human rights. To appreciate the Constitution in its true sense, as it stands today after 75 years, we must first look back at history and acknowledge the monumental task entrusted to 299 members of the Constituent Assembly who were to craft the framework that would govern a free and independent India. Such constitution was to be the rule to govern every citizen. When the Constitutional Convention to draft the Constitution of United States met in 1787 behind closed doors, it adopted a rule that nothing spoken in the House be printed or otherwise be published or be communicated without leave. Therefore, framers of US Constitution, though spoke with greater frankness, but it deprived posterity of valuable insight about what transpired in preparing the Constitution. Contrary to that, the proceedings of the Constituent Assembly which framed the Indian Constitution is like an open book. The deliberation therefore provides an interesting insight into the mental process of those who were entrusted with the task of drafting the Constitution. The debates aid in interpretation and proper understanding whenever a doubt arises. 77 years ago, the Constituent Assembly, convened in the Central Hall of the Parliament, engaged in thoughtful deliberations, passionate debates for 165 days across 11 sessions. Their collective effort was focused on bringing to life the vision of a constitution for a free and independent India, a vision that was once a dream, now a living reality. Standing tall against all odds, Dr. Ambedkar presented the first draft of the Constitution in 1948 with the belief that with a strong constitution in place, India would one day show constitutional morality standing above casteism, which would end caste discrimination. The drafters of our Constitution drew inspiration from diverse global democratic practices, incorporating the best aspects of systems like the British parliamentary model, American federalism, and French ideals of liberty, equality, and fraternity. However, they carefully tailored these elements to suit India's unique cultural, social, and economic context. For instance, to adopt the parliamentary system of governments, a legacy of British rule was accompanied by safeguards to ensure accountability to the people, a sharp contrast to the centralized authorization governance of the authoritarian governance of the colonial state. Though society has advanced, it is essential to recognize that the Constitution has remained relevant all these 75 years, guiding the nation through challenges and progress while preserving its core values of justice, equality, and liberty. However, it is essential to remember that even today there are many in India who still cannot take these freedoms for granted. Access to basic rights, opportunities, and equality remain a challenge for marginalized sections of society. Those who enjoy this freedom must remain mindful of those who do not by striving to secure awareness and equal rights for all, working towards a society where freedom is truly universal. In the last 75 years, The Indian Constitution has proven to be a living document in its truest sense, ably being interpreted to understand and tend to the developing needs of modern society, carefully balancing the economic development and globalization that India is witnessing vis-à-vis the rights of its citizens. The Constitution displays the multifaceted history of India and her ability to adapt to change. In this context, it is of utmost importance to recall Dr. Ambedkar's idea on constitutional morality. In one of his address to the Constituent Assembly, Dr. Ambedkar, while highlighting the significance of constitutional morality, stressed that its core principle lies in upholding the Constitution as the supreme law and adhering to the procedure it prescribes, irrespective of any ideological differences. He emphasized that all three branches of government, persons holding constitutional positions, members of civil society and all the citizens of India in general are all obligated to respect and follow the tenets of constitutional morality. As already stated, the preamble sets the tone for the entire Constitution, expresses a commitment to these values, highlighting that India shall be a republic based on principles of social, economic and political justice. The Constitution, while being a legal document, is also a moral and political contract between the citizens of India and the state. Constitutional morality is essential in interpreting this contract and ensuring that the governance structure operate within the boundaries of these core principles. In this context, it is appropriate to refer to the speech delivered by Acharya J.B. Kripalini in the Constituent Assembly on 17th October 1949 with reference to the Constitution. He said, and I quote, "I want this House to remember what we have enunciated are merely legal, constitutional and formal principles, but moral principles and moral principles have got to be lived in life. They have to be lived whether it is in private life or it is in public life, whether it is in commercial life, political life or the life of an administrator. They have to be lived throughout. These things we have to remember if our Constitution is to succeed," unquote. At the heart of the Constitution lies the balance of power between three branches, namely executive, legislature and judiciary. This careful separation of powers is designed to prevent the concentration of authority in any one institution, which has been the cornerstone of our democracy. The judiciary in particular has played a crucial role in interpreting and protecting the Constitution and has been evolving, keeping in mind the evolving need of the country and the contours of law. The first 2 decades saw the Supreme Court adhere largely to the constitutional text and exercising judicial restraint. This changed with the landmark decision in Keshavanand Bharati in the year 1973, which established the basic structure doctrine, and thereafter in Maneka Gandhi in 1978, which expanded the scope of individual rights and ensured that the Constitution remains ever evolving and responsive to the needs and aspirations of the people. The independence of the judiciary, coupled with an active civil society, has provided the checks and balances necessary to prevent the erosion of democratic values. The Supreme Court has consistently safeguarded fundamental rights while ensuring that the government remains accountable to the aspirations of the citizens. In recent times, we have seen the courts deliberating on highly contentious issues such as same-sex marriages, electoral bonds, Citizenship Act, abrogation of Article 370, and in the case of Sukanya Shanta, wherein the Supreme Court decided against caste-based segregation and division of labor on that basis among prisoners. In my opinion, the most remarkable aspect of the Constitution is its realization of a truly representative democracy. The sheer scale of our electoral process is unparalleled. The provisions of free and fair elections, free speech, and universal suffrage have ensured the vibrancy of our democracy. Our Constitution also encourages pluralism, ensuring that flourishing of diverse cultures, languages, and religions, the recognition of linguistic diversity, the protection of minority rights, and the promotion of secularism have ensured that remains a multifaceted society with space for all. In the last 75 years, the Supreme Court, through its judgments, has not only dismantled colonial legacies but also reimagined the legal system as beacon of equality, dignity, and justice. Many such cases have been grounded on the idea of constitutional morality, asserting that constitutional principles should not be subordinated to majoritarian mindset or hide behind parliamentary technicalities. Such judgments reinforce the idea that constitutional morality demands the dismantling of discriminatory practices, even if they are deeply rooted in traditions. Moreover, constitutional morality plays an essential role in addressing the tension between individual rights and collective good. It provides a framework to resolve conflicts when laws or policies conflict with the fundamental right of the citizens. It ensures that the state power is exercised in a manner that respects the dignity of individuals and upholds the core values of the Constitution. As we look to the future, the journey of 75 years continues to inspire us to build a legal framework that truly reflects the aspirations of a free and democratic India. This transformation has not been achieved by the judiciary alone. It requires the collective effort of every citizen, including the bar. Each of us have a role to play in building a robust legal system that reflects the values of independence, justice, and equality, and be fearless in our approach to grant access to justice to all citizens, irrespective of the social evils that divide us. Members of the legal profession have historically been at the forefront of India's freedom struggle, including in the process of drafting the Constitution. There have been amendments made to the Constitution which were both beneficial and controversial. In all cases where it has offended the basic rights of the citizens, the legal community has always been vigilant thus far. As we reflect on the enduring principles of justice, equality, and fairness that underpin our Constitution, let us remind ourselves of profound responsibility we bear, both as individuals and as an institution, in upholding the rule of law. Our Constitution is not merely a legal document. It is a living testament to our commitment to democracy and the protection of the fundamental rights of every citizen. It is, in fact, the vehicle of nation's progress and is a living thing for the succeeding generations. The question would be, do we deserve such a constitution, and are we adhering to the constitutional morality? This will depend on the persons whom we elect and who govern us. Unfortunately, a major portion of the citizen, more particularly the elite, have shown their apathy and almost ignored the democratic process, resulting in political crisis. We shall do well to recall what Dr. Rajendra Prasad had said, and I quote, "Whatever the Constitution may or may not provide, the welfare of the country will depend upon the way in which the country is administered. That will depend upon the men who administer it. It is trite saying that a country can have only the government it deserves. Our Constitution has provisions in it which appear to be objectionable from one point of view or another. We must admit that the defects are inherent in the situation and with the people at large. If the people who are elected are capable and men of character and integrity, they would be able to make the best even of a defective constitution. If they are lacking in these, the constitution cannot help the country. After all, a constitution, like a machine, is a lifeless thing. It acquires life because of men who control it and operate it, and India needs today nothing more than a set of honest men who will have the interest of the country before them. There is vociferous tendency arising out of various elements in our life. We have communal differences, caste differences, language differences, provincial differences, and so forth. It requires men of strong character, men of vision, men who will not sacrifice the interests of the country at large for the sake of smaller groups and areas, and who rise above the prejudices which are born of these differences, unquote. As members of legal fraternity, we would do well to take note of what was expected by our founding fathers, and it is our sacred duty to interpret and apply the law with integrity, wisdom, and compassion, and also to protect the Constitution by ensuring men of character are at the helm. Let us continue to safeguard the values of the justice and fairness, ensuring that our actions always align with highest ideals of the Constitution and ensuring that judiciary is fiercely independent. An independent judiciary is the heart and soul of a republic, being the foundation of the democracy. In doing so, we will not only honor the legacy of those who framed the Constitution for our benefit, but also shape a future where justice is truly accessible to all. I am conscious of the fact that all of you have had a hard day at work, and I would not test your patience further. Thank you for the patience, and thank you for the opportunity for being before you all today. Thank you. Thank you.
Thank you very much, sir. May I kindly request Justice Dikshit to please deliver the Chief Guest's remarks. Thank you.
Mr. Holla's apology was more than justified. When he was praising Honorable Justice Bopanna, rightly and more rightly, I was just thinking how he would say a few words in contrast with me. I was sitting beside Honorable Justice Bopanna. Honorable Justice Bopanna is Lord of Honeybees. Obviously, he is sweet, and sweetness has not diminished even after he has demitted the office from the highest arbitral tribunal of the country. I should learn that I should try to be sweet, at least to some extent. There was a resolution of the Bar Council which said we should not address the judges as my lords, honorable, this, that, etc. To someone I reminded that there is such a resolution, and still members of the bar address honorable, my lord, justice, etc. Then he told me, adella Justice Bopanna ಅಂತವರಿಗೆ ನಿಮ್ಮಂಥವ್ರಿಗೆಲ್ಲ ನಾವು ಹ್ಯಾಬಿಚುವಲಿ ಆನರೇಬಲ್ ಅಂತೇವಿ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. ನಿಜ ಅದು. Honorable Justice Bopanna, my ideologue. Shri B.V. Acharya, who is rightly treated by judges and the members of the bar as the Bhishma Pitamaha. Mr. D.L.N. Rao, his father was one of my gurus, like Mr. Holla's father. I remember them today. Mr. Holla, learned members of the bar, the students, the community of teachers and friends. Whatever I wanted to cover, because I did not know what would be left to me after all great points are poached by the great person. Still I have to do some justice because I occupied a chair beside him. 75 years of working of the Constitution is not a long period. 75 years is a very long period when we come to individuals. But there should be a fair assessment and auditing of how the Constitution has been working all these years. But before that, now we have only been praising, of course, to a great extent justifiably. Honorable Justice Bopanna referred to doctrine of separation of powers right from the days of Ram Javaya Kapoor's state of Punjab. These principles are of great significance if judges start legislating and if the legislature starts judging and if the executive starts adjudging the legislature and the judiciary. Just imagine what all would happen. Perhaps Montesquieu would turn in his grave. There has been a comment by Professor Upendra Bakshi that our Supreme Court has been functioning as a constituent assembly in continuous session. Many thought that he was praising the Supreme Court, and Mr. Bakshi made it clear that he was not praising. The Supreme Court, under Article 141, which all of you know, High Courts also, we laid down law during the adjudicatory process. And we have been doing it from the days of Lord Edward Coke, when somebody told Edward Coke that judges are meant only to adjudicate. Coke laughed and said, "Don't speak rubbish things before me. We legislate also." But when Supreme Court legislates, we laud because there was need for law. The field was non-liquid. It was not occupied. The conventional legislatures did not legislate, and therefore we legislate. The famous judgment on prevention of abuse at sexual abuse at workplace, which you have seen. But the consequences of transgressing the Lakshmana Rekha is not a happy thing. For a short period, we all will enjoy that we have done great thing. But in the longest run, what is its impact? We have to think about that. I will not say beyond this anything more. Number one. Number two, whether the judiciary as one of the coordinate branches of the state should examine the validity of international conventions, international contracts, defense deals, deployment of armed forces from one place to another. Again, we have to think. There are many things to say the rainbow nature of our Constitution. There are great things which we should appreciate in respect of the judiciary also. But there should be little looking back as to what we have been doing. Can we undertake an exercise to direct the executive to do, which the executive should do, and to ask the legislator to legislate also. This is a question. We can go on praising the judiciary. We can go on praising the legislature. We can go on praising the executive. But that will not be sufficient. We have to see our shortfalls also. I will only remind you what John Adams and Joseph Story. John Adams was the second president of America. What he said when the American Constitution, the Philadelphia Papers were prepared. It's worth reading. I'll just read it. Remember, democracy never lasts long. It soon wastes, exhausts, and murders itself. There never was a democracy yet that did not commit suicide. Just put Constitution in the place of democracy. Because Mr. Nariman writes in his latest book, the last book, You Must Know Your Constitution, that the average lifespan of constitutions in the world since 1789 is 15 to 17 years. The average life expectancy of the constitutions since 1789 till this day is 15 to 17 years. American Constitution more than 200 years. Ours is more than 75 years. But still, what the jurists said, we have to keep in our view. I will also quote Joseph Story, an associate judge of the US Supreme Court, who had said something about the Philadelphia Papers. That was quoted by none other than the temporary chairman of the Constituent Assembly on his inaugural address on 9/12/1946. This, kindly see this. The structure has been erected by architects of consummate skill and fidelity. Its foundations are solid. Its compartments are beautiful as well as useful. Its arrangements are full of wisdom and order. And its defenses are impregnable from without, not from within. It has been reared for immortality, if I want to say so. It may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers. Who? The people. Republics are created by the virtue, public spirit, and intelligence of the citizens. They fall when the wise are banished from the public councils. When the wise are banished from the public councils because they dare to be honest, and the profligate are rewarded because they flatter the people in order to betray them. It depends upon the present age whether the national constitution shall descend to our children in its masculine majesty, not just textual constitution, to protect and unite the country, or whether, shorn of its strength, it shall become an idle mockery and perish before the grace has closed upon the last of its illustrious founders. This is the speech which Satchidananda Sinha, Dr. Satchidananda Sinha, as the chairman of the Constituent Assembly, had quoted in his inaugural address. Just see what Lord Byron Adams has said, that I have read now. Lord Byron says, he's a poet, romantic poet, he made certain comments. Just see this. 1,000 years scarce serve to form a state. 1,000 years scarce to form a state. An hour may lay it in the dust. 1 hour, the state may be laid at the cemetery. And Lord Byron is quoted by none other than Sirvai in his monumental work, The Constitutional Law of India. At the first page, he quotes it. It is very important that, as my Lord Honorable Justice Bopanna reminded, the Constitution as such does not work. It is to be worked with, worked by. Constitution as such is neither good nor bad. It will be a piece of literature. If you go only text by its text, that is not sufficient. Lord Denning, in his first book, Road to Justice, said, give me baddest of the laws. I know how to derive milk from the provisions of such bad draconian law. Give me best of the legislations. I know how can make it draconian. Therefore, not just text of the Constitution. The people who work with the Constitution, that is very relevant. This is what Granville Austin Williams says. Therefore, that we have to keep in view. We are just celebrating 75 years of the Constitution. But look back, what happened in June 1975. Don't be under impression that it will not repeat. June 1975, you know the standard of public morality, the courage of the people those days. The emergency was claimed. 19 months it went on. And they wanted to amend the constitutional provisions. This is what Granville Austin says in his Working a Democratic Constitution. I am just quoting with little words in my language. I may not be reproducing the words. He says it is high time that Indians should be very careful. They should be very careful because efforts were made to elongate the tenure of the parliament beyond 6 years. Those efforts, of course, they did not materialize. These things we have to keep in our view. There are great things which the Apex Court has done. I am only enlisting some of the things which are subject to public debate. When thousands of people are languishing in the jails because their appeals are pending, we are diverting our energy, our time to ensure whether BBMP has made good roads or not, whether BBMP had taken precautions as to malaria or not. That is not the way. Just see, because the focal point of any constitution worth mentioning is the liberties of the citizens. When people are languishing, ಇಲ್ಲಿ ಸೊಳ್ಳೆ ಆಗದಂಗೆ DDP ಹೊಡೆದಿದ್ದಾರೋ ಇಲ್ಲೋ, ರೋಡ್ಗಳಲ್ಲಿ ತೆಗ್ಗುಗಳೆಲ್ಲ ಮುಚ್ಚಿದಾರೋ ಇಲ್ಲೋ, ಅಂಥದಕ್ಕೆಲ್ಲ ನಾವು ಟೈಮನ್ನು ಕೊಟ್ಕೋತ ಹೋದರೆ what the people who are in the galls, what they will say about us, our speeches on the Constitution will be very, very empty. Therefore, there is some debate which Chatterjee, the speaker, Lok Sabha speaker of those days, said the judiciary should not cross the Lakshmana Rekha. That we have to keep on. In fact, T.R. Andhyarujina, the former Additional Solicitor General of India, has enlisted 100 judgments of the Apex Court, saying, bitterly criticizing that we are transgressing the constitutional limitations. He quotes Cooley, Thomas M. Cooley of American constitutional lawyer's statement, when great principles of constitutional law are adhered to by various branches of the state that operate the Constitution, the makers of the Constitution feel happy. Otherwise, one fine day, an hour of folly, the state may be laid to rest. This is another thing. What Dr. Ambedkar himself had said about our Constitution, Kengal Hanumantayya, the architect of Vidhan Sauda, he said, ನಮಗೆ ಮೈಸೂರಿನ ವೀಣಾ ಬೇಕಿತ್ತು, ಆದರೆ ನಮಗೆ ಕೊಟ್ಟಿದ್ದು ಇಂಗ್ಲಿಷರ ಮ್ಯೂಸಿಕ್ ಬ್ಯಾಂಡ್ ಅಂತ ಹೇಳಿದ್ರು. This is on record. He was one of the members of the Constituent Assembly. And Dr. Ambedkar answered. He said, however good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing it are good, it will prove to be good. If things go wrong in the new constitution, the reason will not be that we had a bad constitution. What we will have to say that man was vile. This is what Dr. Ambedkar said. Therefore, in auditing these in 75 years, how various organs of the state which operate with the Constitution, we have to be very dispassionate. We cannot go on celebrating the constitutional morality or these are things, essential things which have to be there, but they are not matter of celebration when certain things are done contrary to the constitutional provisions. And the citizens are let down during the tough times. It is during the tough times we need constitutional organs protection. When we are very happy, when everything, when Titanic ship moves very happily, nobody others, everybody enjoys only. But when there is difficult time, how the courts have responded to the constitutional call, that is very important. Therefore, Bakshi said in his comment on constitutional judgment of the Keswananda in 73, constitutional quicksands of Keswananda. They are quicksands. If we are not vigilant, the constitution may wither away. I will give just another 2, 3, 5 minutes. I know long lecture is not a happy thing to do, but these things I have to tell you. In Pakistan, the constitution was established in 1956. It was enacted only in 1956. Although our Constituent Assembly was for India and Pakistan because it began working with effect from 9/12/1946, much before the advent of freedom. Only thereafter, they created their own. And the second constitution was enacted by Ayub Khan in 1962. The third constitution in 1973. 5 times the constitution was suspended by military rulers. 5 times it was suspended by executive order. Constitution was suspended in a wholesale way by executive order. This we have to keep on our view. Then in Thailand, 18 constitutions have come and gone since 1932. Average lifespan is about little more than 4 years. In Germany, Weimar Constitution was enacted in 1919. It was re-enacted in 1949. Thereafter, many amendments have taken place. Then in Brazil, since 1824, there was only one constitution for 7 years, and thereafter, 7 constitutions were enacted till 1988. Bangladesh, from 1971, first constitution, because Bangla was created in 1971, all of you know. 17 major amendments have been done to that constitution since then, and the identity of the constitution is lost. Therefore, you cannot say constitution is still in operation. In Sri Lanka, 4 constitutions and 21 amendments between 1948 and 2022. Just see this. Uruguay, from 1830 to 1916, 1 constitution operated, but thereafter 4 constitutions had been enacted. Then in Costa Rica, 8 constitutions in the 9th century and only 2 constitutions in the 20th century, because the people of Costa Rica took care to see that the constitutional document endures. It endures. They made all efforts. Many commissions were appointed, comprising of great intellectuals, to ensure how constitution should be, its life of constitution should be elongated. Then, from the lifespan of Latin American countries, the constitution lifespan is 12.4 years. In Africa, it is 10.2 years. In Western Europe, it is 32 years. In Asia, it is 19 years. The mean lifespan of constitutions across the world since 1789 is 17 years. And the experts on constitutional law, including Sir Ivor Jennings, K.C. Ware, our Nariman, Fali Nariman, they say the life expectancy of the constitutions on the globe is fast decreasing and their mortality rate is increasing. Their mortality rate is increasing. What happens on a part of the globe may happen on the other part of the globe where we are all residing. And whatever damage is done to the Constitution, nobody will be able to know, because the constitutional literacy of the people is abysmally low. And our memory is too short to be little. We do not know about Corona now. Just 2-3 years ago, the whole world had come to a halt and we have forgotten. We do not know what all had happened during the emergency. We forget. Our memory is too short to be little. That only 1 minute I will take. How constitutions die. How constitutions die, why they die. This is very important. I have collected this information after taking notes and making little research from a dozen experts in the field of constitutional jurisprudence. I need not name them. They are available in the public domain. I will just enlist them. Military coup. Wherever military coup happens, the constitutions go away. To ensure that it would not happen in this country, the credit should go to Pandit Nehru, who separated all the heads of 3 forces: Army, Navy, and Air Force. Earlier, Mr. Karyappa, Field Marshal Karyappa, again hailing from my Lord Justice Bopanna's land, he was there. But he was a great figure, there was no problem. Thereafter, Nehru felt that where these 3 powers unite at the hands of one man, it would be unsafe for the country. Therefore, he organized in such a way the forces that they will not meet together except once in a month or 2 months. That credit goes to him. Authoritarianism, gradual erosion of constitutional checks and balances by an authoritarian leader or party, is the second reason. Then political polarization, all people divided into 2 parts. One X party, another is Y party. Not a happy thing to happen. Not a thing for celebration at all. Very attractive. Maybe our feelings are assuaged by that one, but that's not a good thing that would happen in any constitutional democracy. The third one is international intervention. This we have to be very careful. I did some work in that. The governments of many countries are toppled, not by war, by miscampaigns. I need not take the example of what is happening in a neighboring country. Just have it. It may happen to our country also. Neighboring country was part of our country just 77 years ago, 79 years ago. Therefore, what happens there may happen in our country also. Then the constitutional flaws, where constitutional provisions of the Constitution are wrongly interpreted and worked with by the organs which are expected to work wrongly, then that is another reason. They say it as constitutional flaws, and they also tell that's one of the reasons why constitutions may wither away. Corruption and abuse of power. Just look into your Google. How many chief ministers were arrested? How many ministers were arrested? See the speech of Vinod Rai. He has given the whole list of people, and the Supreme Court in Jain Hawala dairy matter had to say, you shall not report to anybody in the government. And it included the Prime Minister. You shall report only to us in that Jain Hawala matter. That is a reported judgment. That means I will not say what is the confidence level the people have and organs have in each other, constitutional organs have in each other. Then social unrest and protests. prolonged social unrest, protests, civil wars, which can challenge the existing constitutional order. And there is no much unanimity in the last ground which the authors, some thinkers have said, but I believe it to be true, the substantial change of demography in the country. Just see the history. Just see the history. Read Arnold Toynbee. Read Will Durant and Ariel Durant, The Story of Civilization in 11 volumes. Read Tagore. If the demography of the country changes substantially, I'm not taking any name of the religion, caste community, etc. If demography changes, democracy may wither away. This is high time that I have taken a lot of your time, and therefore, with apology, I am leaving the podium now. Thank you so much.
Thank you, Justice Dixit, for those sobering remarks. May I request Mr. Acharya to kindly deliver the presidential address, please?
Hon'ble Justice A.S. Bopanna, Hon'ble Justice Krishna Dikshit, Shri Udayavalla, Shri D.L.N. Rao, learned sitting judges of the High Court, Justice Venugopal Gowda, former judge, senior advocates, invitees, students, and all my friends. Before my few remarks, as President of the Commission as well as the Trust, I sincerely express my gratitude to Justice Bopanna and Justice Krishna Dikshit for delivering a very illuminating and educative address. I also thank all the learned judges, advocates, and invitees for having participated in this function, responding to our invitation. Thank you, everybody. Now, on the subject, I'll be very brief. My submission will be in the nature of a concurring judgment, because I don't differ from the two learned judges who have, but since we have a practice of even the third judge writing a concurring judgment, I may be permitted to spend some time on this, but I will be very brief. The Constitution of India is hailed as one of the best federal constitutions in the world. The Constitution was drafted and approved by the Constituent Assembly after study, a great deal of debate, deliberation, and research, and after study of various other constitutions in the world. In fact, I am told in the famous case, Keshwananda Bharati's case, they have said there has been reference to about constitutions of 70 other countries. Those responsible for drafting the constitution were stalwarts and eminent jurists. And it was referred about the debate. If we see the debate, though they were all stalwarts having totally different views, the debate was of such a high order, and with all cordiality they unanimously decided to have this constitution. I wish our present-day legislators will emulate how the Constitutional Assembly debates have progressed. The chairman of the drafting committee was none other than Dr. B.R. Ambedkar, generally recognized as an architect of the Constitution. Now I am referring to the name of B.R. Ambedkar not with any political motive, because I am not a politician, nor do I intend entering politics. But nowadays his name is being used as the successor of legacy for the purpose of votes. But we do it out of great respect for the man who was responsible for the drafting of the Constitution. Another legal luminary who played dominant role in drafting the Constitution and molding it till it was approved by the Constituent Assembly was Shri Benagal Narsingh Rao, popularly known as Sir B.N. Rao, hailing from Karnataka, who was the advisor to the Constituent Assembly. He was ICS officer who had served as a judge of the Calcutta High Court earlier. He had thoroughly studied various constitutions of the world and tendered valuable advice. Dr. Rajendra Prasad was the president of the Constituent Assembly, eulogizing his services, stated as follows, I quote, Mr. Rao worked honorarily without any salary. All the time that he was there assisting assembly, not only with his knowledge and erudition, but also enabled other members to perform their duties with thoroughness and intelligence by supplying them with material on which they would work. Unquote. A high watermark in his illustrious career came in 1951 when he was elected as a judge of the International Court of Justice, which position he held till 1953 when he passed away. We salute him. While founding fathers have given the text of the Constitution, the success depends upon those who implemented it. Dr. Rajendra Prasad, in the concluding session, said, I don't want to read it because Justice A.S. Bopanna has read it. Whatever the Constitution may or may not provide, welfare of the country depends upon the country is administered. That will depend upon the men who administer it, etc. And also, to the same effect is the statement of B.R. Ambedkar, which I think Justice Dixit has read. I don't want to read it again. A portion of the statement I will say, the Constitution can provide only the organs of the state, such as legislature, executive and judiciary. The factors on which the working of the organs of the state depend are the people and the political parties they will set up as their instrument to carry out the wishes and their wishes. Who can say how the people of India and their parties will behave? In my humble opinion, equally important is the role of those who are entrusted with the responsibility of interpreting the Constitution. Such a responsibility is entrusted to the higher judiciary, that is the High Court and the Supreme Court, and under our Constitution, and the ultimate responsibility vests with the Supreme Court, which is the highest court of the land. While the Constitution is a lifeless thing, the institution which infused life into it is the Supreme Court, with its skill and ingenuity in interpreting the provisions of the Constitution depending upon the need of the hour. If one studies and analyzes the judgment of the Supreme Court during the last 75 years of its existence, barring some exceptions, it has done remarkably well in protecting the Constitution and the fundamental rights of the citizens and invalidating legislative or executive excesses. Initially, the court confined the scope of rights of citizens, including individual. The court confined the scope of the constitutional provisions literally, ignoring to some extent the spirit underlying in the provisions. Later on, the Supreme Court became proactive and progressive in its outlook. And, thank you. Later on, the Supreme Court became proactive and progressive in its outlook and, by way of interpretation, enlarged the scope and ambit of many provisions conferring rights for the benefit of the citizens. Article 21, 14, and 19 are some of the important provisions. Deviating from its earlier narrow view, with Maneka Gandhi's case, the Supreme Court gave new dimension to the expression life in Article 21 by holding that it did not mean mere animal existence but includes right to live with dignity. The Supreme Court derived its life breath from the directive principles of state policy to stretch the scope of Article 21. In later years, the Apex Court expanded the horizon to include education, environment, medical care, right against sexual harassment, right to select partner, right of reputation, right of information, right to compensation, and even euthanasia, passive within its ambit. This was very much required to meet the new challenges of the society and fulfill the needs of the society. Recently, in the case of Justice K.S. Puttaswamy, the Supreme Court reiterated and emphasized that the right to privacy is intrinsic part of Article 21. The journey of the highest judiciary from A.K. Gopalan to K.S. Puttaswamy, passing through Maneka Gandhi, Bandhumukti Morcha, M.C. Mehta, Godavaram, Olga Tellis, Unnikrishnan, Arun Shanbogar, self-explanatory, emphasizing that every person has the right to enjoy life to its fullest extent. The pioneering creativity of the judges resulted in aforesaid landmark judgments which have contributed in issuing a welfare state. Article 14 of the Constitution enjoins on the state not to deny equality before land, equal protection of laws. Initially, it was interpreted to mean that equal should not be treated unequally and that there should be no discrimination and that any classification should not only be reasonable but also have nexus to the object to be achieved. However, later on, the Supreme Court introduced the dynamic concept of equality and held that article embodies principles of non-arbitrariness. Non-arbitrariness is necessary, concomitant of rule of law. It affords protection against arbitrariness in state action. It was reiterated that non-arbitrariness pervades Article 14 like a brooding omnipresence. In large number of cases, Supreme Court affirmed the ratio, and whenever state action, either legislative or executive, was questioned, the test of arbitrariness was applied to strike down the impugned action. Thus, manifest arbitrariness was accepted as a valid ground to annul subordinate legislation or executive action. And recently, the same principle is held applicable even in the case of plenary legislation, regarding which there is some controversy. I don't want to touch upon it. One of the most important judgments delivered by the Supreme Court of India is the one in the case of Keshavananda Bharati. The court in this case dealt with the power of the Parliament to amend provisions of the Constitution. Article 368 conferred such power of amendment on the Parliament without placing any restriction on such power. However, the full bench of 13 judges of the Supreme Court by majority, overruling the judgment in Golaknath's case held Article 368 does not enable Parliament to alter the basic structure or framework of the Constitution. For the first time, the Supreme Court evolved the new doctrine of basic structure and curtailed the authority of the Parliament to amend the Constitution. This new principle enunciated by the Supreme Court is now well known as the doctrine of basic structure. There were some comments and criticism of the judgment on some legal or technical aspects. However, they were overshadowed by the fact that the people in general and legal fraternity in particular not only welcomed but also hailed the decision as one which saved democracy and in turn the country, as otherwise by now Parliament would have amended the same so many times and to such an extent that as on today we would not have had the present Constitution. Popular acceptance of the judgment by the people generally has totally eclipsed the criticism of the judgment on legal principles. Even with regard to the personal liberty of the people of the country generally, the decisions of the Supreme Court have been in favor of the citizens and against the state, barring few exceptions. One such exception is the ADM Jabalpur case, and one such recent judgment is the one where the entire provisions of the PMLA Act was upheld by the Supreme Court, and though the review petition is still pending, the few judgments recently of the Supreme Court has tried to soften the rigors of those provisions by introducing some new concepts to grant bail, notwithstanding the restrictions placed by the Act. Anyway, the review petition is still pending, but our general view is a review petition is rarely allowed. As stated earlier, India has a strong and independent judiciary. Though each organ of the state is independent of each other and is considered equal in a sense, judiciary occupies a higher position because it has been entrusted with the additional function overseeing that the other two organs of the state act within their scope and jurisdiction, and they do not overlap their limits. Thus, the judiciary enjoys preeminent position, while any wrong or excess committed by the executive or the legislature can be immediately corrected by the judiciary. If the judiciary itself commits mistake, an ordinary citizen has hardly any effective means for addressal of the grievance. Therefore, the judiciary is expected to exercise utmost restraint in exercise of its power. The Supreme Court of India is the most powerful court in the entire world. Its powers are enormous in almost all fields. The power of judicial review, now recognized as the basic feature of the Constitution, and even a Constitution amendment curtailing this power of judicial review can be struck down as offending basic structure of the Constitution. It is a matter of great satisfaction that the Supreme Court of India had by and large acted effectively in the matter of protecting the rights of the citizens. To achieve this object, the Supreme Court has invented new methodology to grant relief to aggrieved people, even though they are unable to approach the court for various reasons. though initially it is only aggrieved person who could approach the court and get relief, in the 80s, the Supreme Court introduced and accepted the notion of public interest litigation. And Justice A.S. Bopanna, as an advocate, had filed large number of such cases benefiting poor people, acting pro bono also. Hence, the Supreme Court introduced this notion of public interest litigation, which are innovative concept, not contemplated by the Constitution. Of course, though it was a good move on the part of the Supreme Court at that time, as on today, we find that in most of the cases, this practice is misused by some vested interest, and large number of such public interest litigations are hampering the work of the judiciary. I therefore conclude by observing that the Constitution of India has served the country very well during the last 75 years of its working, and credit for this should go to the judiciary, which has performed its functions far better than the other two organs of the state. And when I say judiciary, judiciary has done it with the able assistance of the members of the bar, about whose responsibilities you have heard from our learned judges. If there has been any deficiency in the working, it is because of the people and who are implementing it, not because of the Constitution. We should be very happy that though the average lifespan of a Constitution is some 15 to 20 years, as spoken to by them, we should be very happy that our Constitution has already served us well for 75 years, and we are sure it will also serve us in future, so long as we have got an independent judiciary. Thank you very much.
May we request Justice Mr. Acharya to please kindly present the latest edition of his autobiography to the dignitaries on stage.
Friends, one thing I forgot. As most of you will be knowing, I had written my autobiography, all from memory, which was released in the year 2014. Now it's more than 11 years. And now I have a revised edition with some additions have been published just now, and let me have the privilege of handing over those copies to the dignitaries on the dais.
It is my privilege and pleasant duty to finally deliver the vote of thanks for this evening. Justice Bopanna and Justice Dixit, thank you so very much for readily agreeing to come. It was a unanimous choice to invite both of you, and without any formality, both of you have come and graced this occasion, giving scintillating and with different perspectives on the Constitution, asking us to think about, do we deserve the Constitution, and also to think about if the Constitution will last and under what circumstances. Thank you also to the many sitting judges of the High Court and former judges of the High Court who have graced this occasion. Many senior counsel are here with us. Thank you so much for coming, advocates and students and friends of the Commission. I will be remiss if I do not thank the Chief Justice who so kindly agreed to give us this august venue, the Chief Patron-in-Chief Hall, although he could not be with us here today. The many registrars, including the Registrar General, Registrar of Administration, who have kindly helped us in setting up the various facilities to conduct this event. Thank you also especially to the various High Court staff who have worked over the course of the past 2-3 days in setting up the venue and being available whenever we have sought permission and asked them and called upon them. My special thanks also to the office bearers of the Jurists Commission, the Executive Committee, the trustees of the Karnataka Jurist Trust for being with us and organizing this event every step of the day. Thank you also to various members of the bar who have kindly helped us and assisted us in the conducting of this event. Thank you again for coming today and making this event a grand success. Jai Hind. May I request all of you to please kindly stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता